pertaining to grant of compassionate appointment had observed that the same should be based on economic dependence and not on the marital status of a woman. Your Lordship had observed that by appending unmarried before daughter, all married daughters, whether dependent or not, have been excluded from the zone of consideration of compassionate appointments. Honorable Justice Suraj Govindraj was born on 14/5/1973 and graduated from NLSIU Bangalore in the year 1995. Lordship had a vast practice as an advocate, including as a partner at AZB Bangalore and heading the dispute resolution and intellectual property rights practice at Anup S. Shah firm before adorning the high office of additional judge of the High Court of Karnataka on 23rd September 2019. Your Lordship recently in the case of Velankani Information Systems had observed that it is the discretion of the banks to grant moratorium, but it is mandatory for banks to ensure continuity of viable business and that non-grant of a moratorium should not result in adversely affecting the survival and continuity of viable business. In the case of Vishwanath vs. State of Karnataka, Your Lordship, while interpreting Section 153 of the Indian Penal Code, observed that Section 153A can be attracted even if spoken or printed work were to promote or incite enmity between members of the same religious groups. I would also like to welcome Professor Naresh Kumar Vats, Professor of Law and Registrar, Rajiv Gandhi National University of Law, who is giving the welcome address, and our moderators, Mr. Anirudh Lekhi from the West Bengal National University of Judicial Sciences, and presently working with SAM, and Mr. Ganesh Kemka, graduate of NLSIU Bangalore and Senior Law Clerk and Research Assistant to Honorable Justice Suryakant, Justice Supreme Court of India.
Before moving on to the session, we'd like to show you a short introductory slide about the Foundation's work.
Hello.
Aditya?
Yes, sir.
Can
Yes,
you?
yes, sir.
Hello.
So I'll just speak to sir. I'll just speak to Siddharth, sir. I'll just
Yes,
get
please.
something arranged.
I'd now like to call upon the registrar of Patiala. So please.
Thank you, Aditya. Very good evening to everybody, all the honorable dignitaries, honorable Justice Shekhar B, Saraf, sir, sitting Judge Calcutta High Court, and honorable Justice Suraj Govindaraj, sir, sitting Judge High Court Karnataka, the team for Ken Foundation, Mr. Aditya Kandekar, Joint Secretary, Ken Foundation, Mr. Aniruddha Lekhi and Ganesh Kemka, and all the participants. First of all, we are very fortunate to have Honorable Justice Shekhar Saraf, sir, and Justice Suraj Govindaraj, the alumni of NLSIU Bangalore, giving the foundation on this particular event organized by Kane Foundation, dealing with the professional journey and court craft, value and ethics. I'm sure that Honorable Justice Saraf and Justice Suraj Kandekar, they will definitely enlighten the students and all the participants in this August connectivity, because the journey what they have traveled till date by involving themselves in this legal profession, that's a very important. We generally talk that we presume to be in the elite profession, and there are very high hopes of the society from the legal profession, and we are supposed to enlighten the every sect of the society to the right direction. I do remember from the R. Venkataramani, the Supreme Court senior advocate, he has got it in his lecture that there is certainly some increasing perception in the professionals, legal professionals, that whether the emerging lawyers or emerging legal ethics, legal profession is facing the danger or losing its soul. That is the question mark that we are to think of, and we are to at least introspect ourselves, and certainly this matter will be taken up into consideration by Honorable Justice Saraf and Govinda Rajulu, considering even that there is an increasing commercialization, keeping into mind that today in the situation of the competitive world and the global across, whether we are leading to the commercialization of the large profession or the legal profession, which is tending to sell the services, not rendering the services. Rather, the concept of rendering the services, but not to sell the services. And therein, we have to take into consideration all the aspects, the expectations of our clients and the society. There may be the conflict between the statements, a liar is under obligation to do nothing that shall detract from the dignity of the court, of which he is himself a sworn officer and assistant to the court. An over subservient bar would be one of the greatest misfortune that could happen to the administration of the justice. Whether we are rendering our services for the best administration of the justice, can we say the independence of the legal profession, the freedom of speech and the expression, the noble role for the assistance of the court, amalgamation of all these elements, the nature of the law of confidence between the lawyers and the clients, and the continuation of the duty toward the confidence after determination of the engagement of the lawyers, that all the aspects we shall take into consideration, because today with the speed the legal profession is emerging, that the relation between the bar and the bench, the role of the bar and the role of the bench, to what extent the bench is delivering its duties, and to what extent the bar is helping to the bench in rendering the administration of the justice. I welcome Honorable Justice Saraf sir and Honorable Justice Govindarajulu sir, sparing their valuable time that to particularly the scenario which we are facing across the world, the COVID-19. But we cannot simply ignore the social services to the society. So I congratulate the Kind Foundation on behalf of the Rajiv Gandhi National University of Law, the alumni, the students, and Honorable Vice Chancellor. We wish the Kind Foundation to grow ahead and do excellent in the legal profession. Thank you, everybody. Thank you, Honorable Justice Govindarajulu, and thank you, Justice Shekhar Saraf sir, and the team coordinating this particular event, dealing with the very wonderful title of the craft, value, and the ethics in this elite profession of the legal profession. Thank you, everybody.
Thank you, sir. And good evening, everyone. And thank you to the CAN Foundation and the Rajiv Gandhi National University of Law for having initiated this discussion. We are joined today by two extremely illustrious speakers whose career at the bar and their subsequent elevation to the bench has had a tremendous impact on the aspirations of young lawyers and students who envisage a career at the bar. As one of the first products of the National Law University experiment, both our speakers have canvassed individually extremely unique journeys. However, what makes today's discussion extremely significant and interesting is that despite adopting materially different means, they have achieved very similar ends. And this is a subject matter of conversation that will be addressed in greater detail by my co-moderator, Ganesh Khimka. We propose to make this discussion an interactive one. We hope that you find this discussion extremely engaging. Basis my interactions with the honorable judges yesterday, I can safely surmise that they are both extremely warm individuals and will definitely put the image of a stereotypical judge to shame given their youthful zest. So Therefore, without any further ado, I would now want to initiate this discussion further, and I would hand the floor over to my co-moderator, Ganesh.
Thank you, Anirudh, for that very erudite introduction. I think you touched upon a very interesting contrast between our two panelists for today. Whereas both Justice Govindraj and Justice Saraf are from the 1995 and the 96 batches of the National Law School, Bangalore, respectively. Both had very different trajectories, both out of law school and in the middle of their careers, yet them have ended up as judges of constitutional courts in India. Whereas Justice Govindraj, he started immediately upon graduation, he joined the chambers of Mr. Uday Holla, and later in 1997, he set up his own litigation chamber, a firm called Anup Shah Law. On the other hand, Justice Saraf, he joined Arthur Anderson and Co. and he also had a brief stint studying abroad on the Chevening Scholarship. Afterwards, whereas Justice Saraf took up independent practice, Justice Govindraj stuck to his litigation firm, and later on his firm merged with AZB, and he had a stint as being a partner at one of India's largest firms. I would now begin this discussion by putting across certain questions, first to Justice Govindraj, tracing his journey, and later on, Anirudh and I shall move on to Justice Saraf. Justice Govindraj, if I might start off by asking, what made you set up your own litigation firm soon after graduation, and how has your experience been?
Thank you, Aditya Kanderkar, Secretary, CAN Foundation. Thank you, Mr. Dr. Naresh Kumar Vats. Thanks, Anirudh, for your introduction. Coming to your question, Ganesh, as regards setting up a firm after my graduation, it was not immediately after graduation. I started interning with Mr. Uday way back in the year 1992 during the college time itself. Most of the holidays, as also some of the working days, I used to land up at his office to learn something. Immediately after passing out, I joined him, and in 1997, after a rigorous internship and working with him, then I started off on my own and teamed up with Mr. Anup Shah to set up the litigation wing of Anup Shah Law Firm. So it is not that I set up anything by myself, but it was only to set up the litigation wing of the firm as such. And I always wanted to do litigation. It was, though an accidental law student, lawyer, a litigation always drew me, was very tempting and inviting. And that's how I ended up litigating. Hope that answers your question.
Thank you, sir. My next question would be to Justice Saraf. Justice Saraf, in contrast to Justice Govindraj, you went for the traditional route. You spent the dominant part of your career cultivating a private practice at the Calcutta Bar. And I still remember in my days at NUJS, you used to be the names that used to be reckoning among us students, and we all used to look up to you. My question to you is that you came from a lineage of lawyers. Your father himself was a judge of the Calcutta High Court. Do you think that had a role to play in your choice of law as a career? And if so, do you think first generation lawyers are at any disadvantage compared to those who actually come from lineages?
With regard to disadvantage, for first generation lawyers, I don't think that is the case, simply because most of my friends from the National Law School, they did not come from any background as such. And even they have done well in litigation. There are a few who've done well in litigation in spite of not being, coming from a first generation legal, they're being first generation lawyers. But for me, of course, it was a no-brainer. I always knew that law was my forte. I'm going to join law. I mean, I dabbled in science. I did my science in class 12. I did BCom for a year after that. But once I found out about law school and I joined, so that was the way to go for me. So there was no question about that. However, I did not start immediately. After law school, I got recruited into Arthur Andersen, worked there for a couple of years. But since at that point we had that clerkship training program, which you had to do before becoming an advocate, and that Anderson could not provide us. So then I quit and came back to Calcutta to start my practice.
Justice Saraf, if I can ask you a small follow-up question. We heard that you had gone for a short stint of foreign education as a Chevening scholar. Would it be possible for you to share your experience studying abroad? What motivated you to pursue?
I always wanted to go abroad, possibly to become a barrister because my father was a barrister. But since my father became a judge, he didn't have enough money to send me basically. So the next best thing was to get into, get that Chevening Scholarship. It was a 3-month program only. And basically we did 6 weeks with the College of Law, York, where we learned about international competition law and different kinds of stuff and lawyering skills. And 6 weeks with a law firm in London. So it was fun. In fact, that gave me the opportunity with the funds these things provided us to qualify as a solicitor. I took the solicitor's exam over there and qualified as a solicitor of the Supreme Court of England and Wales, which actually helped me a lot later on in my career, because a lot of clients would come simply because, they thought that since he's a Supreme Court solicitor kind of a thing, England and Wales. So, you would get a lot of foreign clients because of that. Thank you.
Thank you, sir. Coming back to the contrast between our honorable speakers today, my question to Justice Govindraj would be, sir, it's widely believed that in order to harbor aspirations of being a judge like you or a senior advocate, one must follow the traditional route of going to a chamber and building a practice there. However, with your elevation, you completely dispelled this notion. So do you believe there is any truth to this notion at all?
The aspect of litigation, there is a misconception you are putting across. The aspect of litigation is litigation in court. So from wherever you're going to litigate, it is going to be a traditional form of litigation, whether you are from the firm or on your own, or you are an association of people, in whichever way that you get to court and to litigate. It is a traditional method of litigation, because whatever has to happen in court happens in that particular manner. And as such, I never had any aspirations or never thought of being a judge. It's just that fate that has got me here. It's God's will. Insofar as the work, insofar as being a senior counsel, it depends on the kind of practice that you are into. And if you intend to be a senior counsel, you better be good at what you're doing. And over a period of time, you get recognized for what you are doing, and then the full court will recommend you to be a senior counsel. So finally, at the end of the day, it's how you deliver in court as a counsel that reaches you as a senior counsel or as a judge.
Thank you for that answer, Justice Govindraj. Building upon that, I would like to ask Justice Saraf a slightly different question. As compared to Justice Govindraj, who doesn't come from a legal background, Justice Saraf, you're a second-generation lawyer, and a lot of people are apprehensive about starting litigation who do not have a prior legal background. I would like to ask you, sir, how has being a second-generation lawyer, Justice Saraf, impacted your practice as an advocate first, and do the experiences of your learned father, who too was a judge at the High Court of Calcutta, affect your decision-making now on that?
When I joined as a lawyer, at that point, my father was actually a judge of the Allahabad High Court. Wasn't even here in Calcutta when I joined the bar here in Calcutta. And the knowledge my father would have got from judgeship, I don't think that was really passed on to me. It was that I saw him and, and lived according to his principles. So that helped me in a way. But definitely being a second-generation lawyer, it gives you a kickstart. But that's about it. People maybe in the Calcutta bar knew me. So that gave a kickstart. However, that should not discourage a first generation lawyer, because anybody who struggles in the profession, and he has to struggle, whether it is the first, second, third, fourth generation lawyer, he has to struggle for the first 5 years if you want to make it big in litigation. There's no two ways about it. Because I remember I left a job of 45,000 rupees a month at that time in 1997, and I came to Calcutta. And in fact, I got married also at the same time. And my father was in Allahabad, and he used to send me 10,000 rupees a month. And we used to just manage with that entire amount. And because I was doing my clerkship, I was not allowed to even earn money at that point in time. And subsequent to that, 1 year also, the next 3-4 years was a huge struggle. But that is the sacrifice which each lawyer who is interested in litigation has to, go through that. Now, of course, I believe the Bar Council, etc., is trying to get a stipend for young lawyers. If that program comes through properly, then it's like really a boon. I mean, it's really going to be good for them. And that would help them to, go through the first 3-4 years. Thank you.
Right, so and just a follow-up question to both our speakers today. In terms of incentivizing young students to join the bar, we are seeing that that's really not happening because there are certain structural impediments to joining the bar. While one of them is, of course, the general tag of nepotism and lineages, another very big structural barrier is the lack of remuneration. And that is why even bright young students from the best law schools today are actually not joining the bar and are going the corporate way, if I may say so. So what are your thoughts on the meager opportunities that are available in terms of these structural barriers that are there existing in the current scenario?
Hello, Anirudh, can you hear me?
I can hear you, sir.
Yeah. So person, and that is why there's a need for support from possibly the Bar Council, and also a change in mindsets of the lawyers who take in juniors. Earlier the concept was that you don't pay them anything at all. You just with you, they learn, and after they get the experience, they are briefed by different solicitors. But I think that change in mindset is required to be brought about, and lawyers should, pay minimal kind of at least, remuneration to the juniors so that they can at least survive the first 3-4 years.
Right, sir. Justice Govinda, would you have any thoughts on this?
To just add on to what just Saraf mentioned, yes, the senior would have to make payment of at least some basic minimum remunerations for the counsel to serve, for the lawyer to survive if he wants to do litigation. Like what just Saraf said, the guts to give up a 45,000 rupee job to come and take up litigation, knowing fully well that he is not going to do anything much. And he was dependent on his father sending him that 10,000 rupees for him to eke out his livelihood. Similar was my situation. I'm a first generation lawyer, again, an accidental lawyer. When we started and during our on-campus recruitment, I did have an offer from one of the premier banks and one of the premier firms, which at that time were offering 15,000 rupees on the on-campus recruitment. But I was my mind was set on litigation and practice. So I knew that I would probably get around 500 rupees, though I ended up getting a little more than that. But I was okay with 500 rupees to start off. But from 1995 till now, I think we have progressed quite a bit, and most of the councils, most of the seniors don't grudge payment to the juniors as long as there's a contribution from the juniors bottom line of that senior. He would generally pay. Now, the problem that I see is that most of the young lawyers compare the amount of money that they are earning to what their colleague or their peer is earning in a corporate environment. They cannot be, they're apples and oranges. They cannot be a comparison between what you would earn in a corporate environment to what you will earn as a litigator. As a litigator, you will earn much, much lesser because your contribution does not start on day one. Your contribution is only when you are able to link 3, 4, 5 enactments, weave a story around it, pull it across, The client has confidence in you for you to take it up. You are able to draft. You are able to go and argue small IAs, big final arguments, whatever. It takes a little longer time. Having said that, what happens is it is all dependent on you as a lawyer as to how much you can contribute. How quickly can you do it? There are people who have done it at a very early stage. There are people who have taken a long time to do it. But here I would probably say that as a corporate lawyer, you start high and you plateau out over a particular point of time, or the incremental value that comes out of the earning plateaus out over a period of time. For a litigator, I would draw the analogy of Benjamin Button in terms of you start old, earning less, but when you become a senior counsel or you become a senior lawyer, there's no comparison at that time. It is a survival for the first few years. It is your learning. It's your understanding of things. It is the client having confidence in you. It is your senior having confidence in you to give you the matter to go and argue, because each matter is important for that client. It is not something that you could just go and experiment. Once you get that confidence, you will go and do things. You will contribute. Then you will start earning. It's a process. It takes some time. Be at it. Do good. Definitely make it. Don't do any comparison.
Thank you. Thank you for the answer, Justice Govindraj. I think that both you and Justice Saraf made some very interesting points. Justice Govindraj, as you pointed out, that litigation should not be compared to a career in corporate law, because the career graphs of both vary very widely. Whereas for a litigator, it starts off low and increases exponentially after a couple of years of experience. For a corporate lawyer, it plateaus after a while. And I remember, Justice Govindraj, when I was speaking to you today morning and discussing the theme, I remember you gave me an analogy saying that if you compare the fees of any senior advocate in Delhi with that, what is being earned by even a senior partner at a tier 1 law firm, it would show the futility in pursuing corporate law merely for the monetary reward. And Justice Saraf, I feel that the words and the wisdom which you told, insofar as everyone will have to struggle, and merely because someone is a second generation lawyer doesn't mean that he is at that a first generation lawyer will never be able to compete with him, and that these differences, although they exist, but are usually restricted to the initial few years after graduation. With that, I would now like to request Anirudh to move on to the second theme for today, which is on court craft and ethics. On to you,
Anirudh. Thank you so much, Ganesh. Sirs, in 1984, in a very famous interview to Time magazine, Nani Palkiwala had said that if you file a suit today in India, it will be decided in the next century. Ironically, when Mr. Nani Palkiwala was establishing the jurisdiction of Indian courts in the Bhopal gas tragedy case, it was this very interview that was cited by Union Carbide Corporation in the courts in America to suggest that there will be a denial of justice in India, which is why Indian courts should be denuded of their jurisdiction. Therefore, what I'm trying to say is that the Indian courts are infamous for the high rate of the low rate of rather justice dispensation and the high rate of pendency. Therefore, my question to you is that, like in other jurisdictions such as the United States, where there are certain calls for example, prescribing time frames within which pleadings may be filed or time frames within which arguments may be laid down, do you think these kinds of solutions are in any way viable? And I say this primarily because there are two kinds of problems that are plaguing the system. There are certain kinds of systemic problems, such as the low judge to population ratio, which is not in our control. But there are other problems, such as the ones that I have pointed out, which are within the remit of the officers of the court. And therefore, do you think that these are viable solutions? And what are your thoughts on the problem to begin with? Justice Saraf? I think we've lost Justice Saraf owing to a technical glitch. Would Justice Govindraj, would you like to answer the question?
Yeah, I'll take it in the meanwhile until Justice Saraf joins. You were speaking of three aspects to it. One is the systemic aspect in terms of low.
Is the question
I think Justice Saraf is speaking, but because of signal connectivity, there is. Continuing from where I was, you were speaking of the low judges to the population ratio. Rather, what we need to look at the judges to the litigation ratio right now. This population ratio does not mean that all people end up litigating. By far, India, in terms of the population to litigation ratio, it is much lower than what is in the US or any of the Western countries. We are not that litigating culture as such. But what is of worry is the low judge to the litigation ratio. Some of the district courts nearly have around 4,000 to 5,000 cases before them. So they are dealing with around 4,000 cases at any particular point in time. The pendency only mounts because we are always trying to play catch up. We are trying, the number of litigations which come into the number of disposals are a little lower. But having said that, please also look at the number of disposals per se. You'll be surprised that the disposals are pretty high. Despite all of it, the disposal is very low is because the judges are working on it and are dealing with those matters from time to time. If we have more judges, if you want to increase, for example, if you want to bring it to zero, if you want to increase the productivity in assembly line in a car manufacturing plant, what do? You'll probably put up one more assembly line. You'll have more number of judges. It is having more number of judges which will probably have an impact on playing catch up and at some point of time overtaking the number of filing.
It is okay. Don't touch the light.
Reduce it. Having said that, the second question that second part of the question that you had was regarding fixing of time for the purpose of argument, like as done in the United States courts. Now, that is something which the United States courts have over a period of time, over decades, to that particular situation, where people have adapted to it, people have evolved to it and reached a particular stage where they could fix a time for a particular lawyer to finish his arguments and as also submit a detailed written synopsis. Well, we in India are in a different situation. We can't compare ourselves to the American situation. We can't ape the American judicial system as such. We'll have to find our own. Having said that, insofar as the time which is taken for a particular argument, the judge who is presiding over a matter is the best judge how much time to give a particular counsel for argument. The judge, believe me, will not give more time than what is required for that particular matter to make his submissions on. Maybe a little more because it is a question of principle of national justice. Party has to be heard. You have to give that party, that lawyer, and that party adequate time to place a case before the court. Some lawyers may be able to place it very quickly. Some lawyers may be able to place their case before the court. So restriction of time, I don't think may be a solution for it, but we'll have to see how it pans out.
Can I come in on this point?
Yes, sir. Please.
Just to supplant what Justice Govindraj said, I have been doing this in the sense limiting time frame for arguments in certain matters. But I can tell you for a fact, it's impossible to do it for all kinds of matters. Some matters you can, and of course, if it depends absolutely upon the judge. Like certain judges are able to stop the lawyers from talking. say that that's enough, I don't want to hear anymore. But certain judges are not able to do that. So, it's very individualistic also. So, this is something, but yeah, we need to move, we need to cut down on the arguments, because the traditional lawyer in India would want to argue the entire day. Unless you stop him, he's not going to stop. So possibly there is a need for change in our mindset also, the judge's mindset also, to try and, now what is happening now when we are doing matters in Zoom, when we are doing all this in the video conference, a lot of judges, if you see Delhi High Court, I saw, just directions for notes were given, along with their judgments, and they were allotted 20 minutes to argue their case. So that is something which is possible, feasible, but we have to move towards it. But it's not going to happen overnight.
Thank you for that answer, Justices Govindraj and Justice Saraf. It's a very interesting, nuanced distinction between what both of you have said. Whereas Justice Govindraj feels that although we do have a problem of high pendency, but the issue should not be looked at as a low judge to population ratio, but as a low judge to litigation ratio. Further, Justice Govindraj pointed out that how the burden and the efficiency of at least High Court judges and Supreme Court judges is quite good insofar as they dispose of a lot of matters in a particular day. On the question of having allotted time limits for arguments as propounded by my co-moderator Anirudh, there is a very interesting distinction, whereas Justice Saraf feels that there is some need for intervention and possibly some need for change, both insofar as advocates themselves try to change their mentality and restrict their arguments, and the bench should guide them towards it. But Justice Govindraj feels that it is individual to every particular lawyer, and it is only natural justice that you allow that particular advocate to make his case. I would now put on a follow-up question, starting with Justice Saraf, particularly, now that he has touched on virtual courts and his experience on dealing with advocates with the same. Justice Saraf, how has your experience been with virtual courts? Do you think these can and should continue even after the COVID pandemic subsides?
Why not? I mean, I don't see a problem with that. If certain counsels request for video conference because of certain issues of not being able to come to court, I'm sure we will accommodate. There is no issue. However, when the matter is being done in court, traditionally we've seen that, and today also possibly we are more comfortable doing it in court, simply because the infrastructure for the video conference is not up to the mark till now. If that comes into play, if everything is up to the mark, then I don't see any distinction between the physical hearings and video conference hearings. Of course, I think judges also, along with the lawyers, need to be trained, because there are lots of, like, suppose you want to share a document. If you were to ask me to share a document, I wouldn't be able to do it today. But if I'm trained to do it, I can do it. Similar for the lawyers, when they want to share documents, etc., on screen. That is a problem which is happening, because today also, like the other day, I was doing a matter. So they wanted to show me a particular judgment which they had not handed over earlier. So that couldn't be done on the screen. But fortunately, they had kept a junior in court physically, and so that junior handed over the particular document to me. So ways are there to come out of it, but I don't see a problem doing video conferencing even subsequently. However, I think there is a need for a training amongst the lawyers and the judges to get fine-tuned into this process. That's all.
Thank you, sir. So you very rightly pointed out certain structural problems that persist in this e-litigation system. And to that extent, you are correct when you do infer that they cannot be complete substitutes to normal courts. And to that extent, that's absolutely right, sir. So my question is with respect to the other systemic problem that persists. And to that extent, my question to both of you is that as high courts and Supreme Court, these courts are meant to be courts of record. And to date, the only record that exists of a development that takes place can be only garnered from the order sheet of the court. So my question to you is do you think transcribing proceedings is a good option? Because in my experience, what I have felt is that if a judge is not amenable to a particular position, he ignores that point altogether while delivering his judgment. And to that extent, impugning that judgment becomes even more difficult. And therefore, as courts of record, do you think transcribing proceedings is imperative?
Suraj, you'll take it first?
You go ahead.
Acha, no. You see, when you say transcribing, if you're saying recording the arguments of the counsel, that's not a problem. I don't see a problem. I think that's a great idea because that would help the judge also later on. He can refer to it and, he doesn't miss out anything when he's writing his judgment if it's reserved judgment. I don't see a problem with that at all. It's, in fact, this transcribing can possibly be done by way of video so that, it doesn't have to be typed, etc. It just comes in a kind of a dictaphone kind of scenario and it's recorded. So that would help, I am sure. But if you're talking about live streaming, then that's a different issue. Because I'm not really in favor of live screening or streaming of, all the matters, simply because then when there's a, video in the court, the banter between a judge and a lawyer, the laughter, the kind of, reprimands which would go on, things like that, that would decrease. This court atmosphere will become much more serious and the fun would be lost. So I wouldn't, unless it's very much required that a live streaming of a judgment of a proceeding is required, that only in certain circumstances. In fact, Calcutta High Court has ordered one very recently. In case of the Parsi community, I remember, just very recently. But, it's only if it's absolutely necessary that should be done. Otherwise, there are the media, of course, you can ask us that later regarding the media. That's about it. I think transcription is not a problem at all. Suraj?
Anirudh, what you're speaking of was e-court or a virtual court or e-litigation is what you broadly put it under. Today, what we are working so-called virtual court, there's actually nothing virtual about it. It is basically a stopgap arrangement that has been resorted to in view of the exigencies, in view of keeping the doors of justice open, because there are matters which come up and there are only emergent matters which are being taken up because they need to be addressed. The methodology that is being followed right now is a lawyer files the case by sending an email through email of a scanned plaint or scanned writ petition or scanned bail petition, which is taken, which the registry downloads, prints, and puts it across to the judge. You read the physical thing, the lawyer and the client is probably sitting peacefully at home so that he is safeguarded against the COVID pandemic that is there. But the judiciary as such is functioning from court. The judges are sitting in court. The staff of the court, the registry, everybody comes to court. Everybody is there in court because we don't have a system. We don't have the technology to do it in any other manner. Now, if you speak of e-court as such, as what is there in New Zealand or what is there in UK, part of it is that you have a e-filing system where the pleadings are filed in a particular manner into a particular software. The payment is by way of credit card or e-wallet or net banking. You can apply by certified copies in a e-methodology. E-certified copies could be given. Basically, at the end of the day, you need integration with the databases. For example, the post office database, the database of the police and prison, the land revenue. If all those things get integrated, then we are speaking of an environment where we have a e-court as such. When we reach there, that means a lawyer or a judge can walk into the court without anything, probably with a computer or with an iPad, and conduct the proceedings. Having said that, now, which are the lawyers, which are the litigants, and which are the courts which can do this? What is the quantum of money which is required to set up this kind of infrastructure? It's a very nice idea to have a e-court, very nice idea to have representation by way of video conferencing. But can we actually do it? We have 1,100 High Court judges, 34 Supreme Court judges, 25,000 or so district courts and Taluka courts and district judges and CJMs, etc. How are we going to set up an infrastructure for all these people? We can't be elitist in this in terms of saying that we cater to Supreme Court lawyers, senior counsels, or to the High Court. We have to look at the Ram and Sham litigant sitting in Impal, sitting in Jaisalmer, sitting in any small district that you can think of. They have to have access to this. So this is not a one-size-fits-all situation. Coming to your transcription. So after this pandemic, right now pandemic, we are there for the purpose of keeping the doors of justice open. But after the pandemic, if the Ram Sham has to approach the court, he has to do it physically because he may not be able to approach electronically. There's no methodology for him to do it. Coming to your transcription aspects, probably again we get a little enamored by what happens in the American legal movies where you see a court reporter pecking on to a machine and it is transcribed and everything is available. That is what people want. I did make my inquiry. That machine is called a stenotype, and that machine costs around $5,000 plus training. So if we are going to have 34 in the Supreme Court, 1,100 for the High Courts and 25,000 for the district courts, how much is it going to cost? Who are the people to operate it? It's a wonderful idea to have a transcription. Believe me, I think Justice Saraf will definitely agree with me that once I get a transcribed copy as a printout, it refreshes my memory. It makes it very easy for me to dictate a judgment, because many a time, though we have made detailed notes, there are some blanks where you break your head over, okay, what was this argument? Then you are putting it together. Get a transcribed copy, it would be fantastic. But where is the money? UK is investing $2 billion to ramp up its infrastructure on court system. Can we invest that kind of money? If we can, let's have e-courts, let us have transcription, let's have everything.
Thank you for that answer, Justice Govindraj. I think it's very interesting for our audience, the contrast again between the answers which you gave. Whereas Justice Saraf thinks that theoretically, virtual courts are a good idea, and in many ways they increase access to justice for the masses. Justice Govindraj pointed out that how there are practical difficulties, as the internet is still something which a majority of our countrymen do not have. And perhaps by shifting to virtual courts, you are both increasing the costs and the resources and the infrastructure required, as well as limiting the reach of those courts to a certain section of people. But on transcribing, Justice Saraf very appropriately pointed out that banter is a very essential part of courtroom communication, and a certain level of frankness is required between a lawyer and the judge, and that might be lost if the proceedings are live streamed to everyone. I would now ask a follow-up question coming from this, because even right now, a lot of proceedings, we see that there is a lot of tweeting or legal reporting of the proceedings which happen in various high courts as well as in the Supreme Court. Do you think that that this media coverage and a lot of critiques which are authored by academicians and practitioners affects dispensation of justice? If so, how?
If I'll take it up first. Lots of times we see that, this lawyer said this, the reply was the judge said this, and, these kind of things come up in the news, talked about in the TV media. That's extremely unfortunate because, frankly, the people who are covering this, even if they are legally trained, they would not be really aware of the circumstances as to why that communication took place. Therefore, such kind of reporting, in my view, should not happen. Simply because the people who receive the news, they may not be in a position to really understand why that particular interaction took place. And then, from one point it goes to another, and how it is with the social media. So that is something which is well avoided, frankly. So, and of course, the legal reporting that happens should be with people who have some legal experience, which is not always the case, but preferably that is the way it should be. Justice Govindraj?
Completely agree with you, Saraf. The reportage as such in the social media is truncated. It is only what one person wants to say, and in court, what happens? Basically, social media is writ large. In court, what happens is there's argument by the petitioner or the argument by the respondent, and they are face to face, and there's a decision which is taken on it. But in social media, what happens is a truncated, one-sided version which goes in one tangent, the other version goes in another tangent. Neither of them mean they're parallel. People make their assumptions or their decisions on the basis of this truncated media reportage, which becomes a problem.
Right, sir. Sir, you're very right when you both say that sometimes, if not most, reporting is inaccurate, where portions are selectively excluded, perhaps because of the motivations of the journalist, or perhaps because of lack of an understanding, as Justice Saraf was pointing out. So my question to you is, the fact of the matter is that this reporting still does take place, unfortunately. Having said that, do you think that judges are cognizant of this aspect, and therefore they also tend to play to the gallery for this very reason?
One can't speak for other judges in that sense. I mean, whether they do play to the gallery or not. But by and large, I don't see that being an issue. It's frankly more, the reporters who want to sensationalize the particular piece, and, social media getting onto it. And I don't think it's a case of any of the judges wanting to sensationalize and therefore making comments, unnecessary comments in the court. I mean, that it's a natural process when an argument is going on between a judge and a lawyer. There is going to be banter. There is going to be time when a judge is going to get angry at a particular manner in which the lawyer is going on about, a particular argument. The judge may have asked him to stop, move on to the next argument, but the lawyer insists on continuing with the same argument. A lot of these instances may happen, but that is something which is part of the court craft, how we deal with it. It's a learning process for the judges also, the learning process for the lawyers also. So really, it's not a question of anybody wanting to get, any media coverage out of it. In fact, as judges, I remember when the moment I received my my news that I'm going to become a judge, I called a friend over to my office and he removed me from Facebook. That was the first thing I did, get out of Facebook. I'm not on, internet, and I'm not on Twitter. I'm not on the Snapchat and all my daughters do all this, but so we are not into this. At the most, we are in WhatsApp groups, that also closed groups, and so we don't want our judgments, etc., to be sensationalized in that sense. Yes, of course, there are certain judgments which are important, which need to be brought forward to the citizens, that nowadays anyway, all the legal sites, etc., are doing. So there is no requirement to sensationalize at all, in my view. Thank you.
So if I may ask one very small question before moving on to theme 3. I've been told that we're running slightly on a delay, but just a very small question. Trend of advocates and bar associations refusing to appear for certain organizations or individuals. Do you think that this is fair? And if so, how should young advocates learn to deal with contentious issues?
Let Justice Suraj take this. Suraj?
To a limited extent, a lawyer can decide where he wants to appear or for whom he wants to appear. But the association passing resolutions to say that no, so-and-so we can't appear for so-and-so, that the Supreme Court has already held in many matters to be illegal. The associations cannot do. it is like buns. There are things which keep on happening. It's for the lawyer, young or old, to decide whether he wants to appear in that particular matter or not when approached. Of course, he can't be an ambulance chaser and look for the case. If the party were to approach him or her, it is for that lawyer to decide. The other opposition should not come in the way.
See, in India, if I may add here, we have a very strong legal system functioning in the sense that suppose a particular lawyer doesn't want to take up a matter, that doesn't mean the litigant is not going to get another lawyer. Let us say a set of lawyers in a particular court, district court, say that we will not appear for this person for X reason. It could be a politically motivated reason. It could be any reason. Then the court appoints. We have legal services. The court would appoint somebody and the matter would proceed. And that's the basis. You get a fair trial. There is no problem. Just because there are certain cases that come up and they are sensationalized, I think we should stop that. And there are very few cases where a litigant will not get a lawyer. I mean, there are enough lawyers who want to appear in controversial cases also, for that matter. So it works both ways. Thank you.
Thank you, sir. I'll just like to wrap up this theme for our audience. So we have fairly reached a conclusion while discussing courtcraft and the way the courts are functioning, that it is not always correct to look westwards, and solutions that may seem to be appealable may not be strictly suited to the Indian dispensation. And to that extent, our speakers are absolutely right and are completely accurate. We have also spoken about how judges don't always tend to play to the gallery, and the fact that there are numerous really competent advocates who would provide a rather able representation to the clients, which is an aspect that is normally missed out when these issues are sensationalized again by the media. Now, without further ado, I would now want Ganesh to commence the discussion on our final theme today.
So we are moving on to theme 3 now, which is on NLUs and young advocates. Most of our audience today is comprised of young advocates, mostly from NLUs. These institutes were famously founded by Professor Madhav Menon to raise the quality of the Indian bar. But counterintuitively, many of these very NLU graduates have been joining law firms or corporate law as they harbor apprehensions against joining the bar for multiple reasons, as we will be discussing in this session. They feel that, for example, that the profession is extremely cutthroat, where survival is impossible without legal lineages. And with this, I will now ask the first question to our honorable judges. How do you, Justices Govindraj and Saraf, look at the NLU experiment? Do you think that it has been successful?
Yeah, I'll take it up. You see, when National Law School was established, I believe back in 1988, at that point, there was a real requirement for these national law universities to be established. The legal profession was seen as the last resort. If you don't get into engineering, you don't get into chartered accountancy, you can't get into any other good profession, law to hai, law kar lenge. That was the attitude. Law is always there. You can always do law at any point of time. You study history, you study geography, you do science, you can anyway do law thereafter. So the entire approach towards the legal profession, legal training was not there. What Dr. Menon did was he brought in a methodology, a process by which a proper system was established for National Law School, for the study of law. And National Law School being the first, and thereafter the several NLUs, the NUJs thereafter, Bhopal, all these places. I mean, now we actually see a host of quality lawyers coming out. And it is, it's a, maybe you're right when you say that a lot of the students don't go into the litigation sector simply because there is a requirement to earn money. You know, it's not that attractive in terms of money. A corporate would pay you much higher in the beginning. But even if, let us say, 20% of the persons who come out of these NLUs get into litigation, you know, it's a huge success, the entire experiment. And look at the training that is now being imparted. Earlier, law colleges were evening, 3 hours. I mean, I remember, I don't even think they would attend those colleges. You know, you would just take your exams and pass. But now there is a proper training that is going on. I mean, you learn interpretation of statutes, you learn how to go about things. There's a court craft, we have these moot courts, mock trials. You know, they are actually giving you a proper training. Therefore, the average lawyer that comes out is going to be far, far above what he would have been if he was in a 3-year law college, you know, which was just imparting law as just a curriculum kind of a thing. So the entire standard has gone up. I mean, there is no doubt about it. Today, when I look at the interns who come to intern before us, I feel ashamed when I think of my days when I went for internship. For me, it was like a party of 1 month. We hardly did any work. You know, so it's very different now. It's people, these students are very serious. In fact, I would like to tell all the law students here who are hearing this program is you need to chill out a little bit, you know, because this is the only time you're going to be able to relax, because after these 5 years of law school, it's going to be a lot of slogging that's going to go into it. So enjoy your 5 years. Of course, you need to work. All of us we work, but you must enjoy those 5 years. I think law school, by my 5 years in Bangalore, I did everything but law. And I think it's turned out fine for me, so it's not a problem. Justice Govindraj, please.
Yes, Saraf is being very modest. We know why he is here after and how he got a Chevening Scholarship. Being a little modest on that. Anil, what you said was, as the National Law School experiment failed, is what I heard you say. It is not. I think it's been super duper success. We have had law school which started from 1988. The first batch came out in 93. I was the third batch of 95. Just Saraf was the fourth batch of 96. Now, in what yardsticks are you looking at the success and the failure of law school? Number one, litigation, if you want to look at litigation as such. With just around 60 students per batch for the first nearly around 10 years, we have had litigators across the country. It's not distributed across the country. We have got, for example, my batch, we have litigators in I was litigating in Bangalore, we have a litigator in Cochin, we have got litigators in Madras, we have got litigators in Andhra Pradesh, we have got litigators in Maharashtra, Delhi, Calcutta. You name it, they're everywhere. It's only the numbers, once they're spread out, you don't see that many numbers. There are litigators. There are, now, for example, speaking of judgeship, now there are 5 judges from the law school. The eligibility being 45 years. Most of the people became 45 in 2017. So if you look at it, in 3 years, law school has given 5 judges.
National Law School alone.
Has given you 5 judges in 3 years. Can you call that a failure? I would say no. Now, when we speak of justice delivery system, we are not only speaking of litigators and we are not only speaking of lawyers. The corporate counsels are an integral part, because without the, now with the litigations that come about, we need a teamwork between the corporate counsel and the litigator. There are a lot of things that a lawyer who is a litigator does not know. The domain expertise is not there. The domain expertise comes from people who are the GCs in that particular companies. Today, most of the GCs across the top countries, the national or multinational or transnational, today in India are from National Law School or NALSAR or NUJS, because they came in succession and they have had time to grow. Most of the GCs are from there. There are firms like Trilegal, which has been founded by people from law school. It's one of the largest firms today in India. We have had other firms which have been founded. The decision makers in most of the firms today, the equity partners in most of the firms are from law school or NALSA. How do you say it has failed? I would say no. We have had probably around 10 district judges also from law school, if you're aware or not. We have had advocate generals, we have additional solicitor general, we have additional advocate generals from law school. We got a chancellor sitting on the Facebook board for I don't remember the name exactly, but we have the director of law school sitting on that board. I don't see it having failed. Now coming to the next part of it on education. Aren't all the other colleges imitating the law school experiment? Whether moot courts, whether any of those things which were available in any other law colleges earlier? No, they did imitate in the beginning. Imitation is the best form of flattery. But thereafter, they have also been innovating. They have also been giving the law schools a run for their money. Jindal Law School is giving a run for the money for most of the law schools. They have imitated, they have grown out of it. There are people who have graduated, who have done extremely well for themselves. And now today we have got 60,000 people taking up a CLAT exam. And around similar for the LSAT exam. Did we have anybody hankering upon a legal career? As Justice Saraf said, it was the last resort. Only law school made it a viable profession, and today it has become a very viable profession. People want to be a lawyer. I don't see, it's a very limited, very microscopic view of the fact. Law school, I believe, has succeeded in manners way beyond what we could think of.
Thank you, sir. I'll now just preface my next question with a small anecdote about Mr. Madhav Menon, which is very popular in the NUJS circles, and I, as a graduate of NUJS, would want to mention it here. In 2001, Professor Madhav Menon, as the Vice Chancellor of NUJS, had actually gone to NLS Bangalore, and in a speech very famously proclaimed that NLS has been a failure, and he thumped the podium. And he then said NUJS will not replicate NLS, and it will be a success. And perhaps his understanding was that because of the increasing corporatization of law school, he was disappointed. Now, come 2005, you had numerous students that were again being recruited from NUJS to the top tier law firms, and to that extent, he would have again been disappointed. But I think Mr. Madhav Menon was only being a teacher who would just want his students to do better. And to that extent, I do completely agree that the law school experiment, the 5-year law school experiment, has been an astounding success. However, having said that, the fact that it has become a success, I have seen in my interactions, students from national law universities hold the fact that they come from national law universities as a badge of honor. And to that extent, there exists some elitism between people who are from national law universities and those who are actually not from national law universities. Therefore, I have seen also in my professional experiences, people, very, very competent individuals from non-NLUs being on a different pay scale at their workplace. Now, having said all of this, given the fact that we all agree that the law school experiment has been a failure, do you think that the quality of students that graduate from national law universities is in any way better than those who come from non-national universities?
Anirudh, I'll take this. Number one, as Justice Govindraj pointed out, we actually believe that it has been a huge success. You have people in all sectors, as he pointed out, leading those sectors. And the fact that when you come out of law school, you have a chip on your shoulder. I mean, it's like coming out of an IIT, you know? So if you've come out of the best of the best, you are going to have a chip on your shoulder. Like I'll give you my example. I came out of law school, got into Arthur Anderson. You know, I thought I was the man at that point of time. And then when I came into Calcutta and joined my senior, Mr. Bajoria, who was the last word on income tax in Calcutta, income tax, direct and indirect taxes. and joined him, that's when I realized that I had no clue. I really realized that I had not really learned any law in my 5 years of law school and my 2 years in Anderson. So, when I really joined the litigation sector here, and I remember my senior telling me that if you are able to prepare one brief properly, you will get to learn about every facet of the law, whether it be CPC, CRPC, evidence, writ jurisdiction, everything you will get to know. So, having a chip on the shoulder, and that's when I realized, and I fell flat, and I realized that I had a long way to go. And, that's when you really start working hard. But the very fact that you are from a law school gives you an edge in the sense that, again, it gives you an edge when you start off. It's like a bouncing board. But you need to carry forward that entire thing. And the fact that you've studied in a good university gives the average student from that place an edge, simply because he has learned, certain things which would help him, like how to research in law, how to draft in law, how to interpret a law. So that learning is better. So if he uses that in his later life, whether as a litigator or as a person in a law firm or as a person in a corporate sector, it's going to stand in good stead always. It has to. There's no question about it. Now, the fact of, this elitism concept has been going around, whether everybody who comes out is elite from the law schools. If you're from the national law school, you think you're an elite, or national law school thinks itself to be elite. I don't think that's the case, really. I really don't think so. Yes, if you're going to call the best to be elite, then yes, maybe so. Why not? IITs, IIMs, if you come out of IIM Calcutta, or you come out of, one of the top IIMs or the top IITs, you have come out of the best because you were the best. You got in, you went through a competitive exam, you got in, you've studied there, you've come out of it. But all of us who come out of it with that chip, very, very soon we realize that it's all nonsense, and you need to really put down and start working now. That's it. When you get into the working field, that's it. Thank you. Justice Govindraj.
Agree with what just Saraf did mention. See, what did law school give us? Law school gave us a work ethic. Law school kept us on our toes throughout. We had our project submission, midterm exam, or Viva OC, or end-term examination. Socratic method or otherwise, it taught us to be innovative. Burning the midnight oil was never a problem. We would always do that. We have continued to do that. We have ingrained the work ethic and innovativeness. Having done that, most of the students from law school have been quite successful in what they have done. That does not convey elitism per se. What we have to see is that you're focusing on this particular small group of law schoolites, whether it is from the National Law School of India, University Bangalore, or NALSA, or NUJS, or any other college. You're just focusing on a few things. But aren't you ignoring the successful people from the other colleges who have made good? Haven't students from other colleges become advocate generals in the recent past, in the same length of time that we have come into being, that law school has come into being? Once you get into the sea, you have to either swim or drown. The chip on the shoulder, if you think it is a chip on the shoulder by being from the law school, is not going to work as a life boat or a life jacket and for you to float around. You have to swim. Having said that, what happens is most of the law school graduates end up practicing in the metros. How many of them practice in the mofussil areas? There we haven't been able to make an inroad, because they do not have the access to the resources that a law school graduate has. If they have the resources, believe me, they would have done fantastically well, and in spite of which they are doing fantastically well.
So in fact, can I add over here? There are people I know from the NLUs who are now practicing in smaller towns like Siliguri, etc. And in fact, the people who are hearing in, I think it's actually an opportunity for students who are from smaller towns and have gone to NLUs to actually set up shop in those smaller towns. It may be a smaller cake to eat from, but with your contacts and with all your friends in your batch and other batches in NLU, it worked in my favor, because when I started my shop here, in that sense, I got work only from National Law School. People all across, my friends were in banks, they were in the top law firms in the country. And then work, there was no problem. There was no dearth of work. There was so much work. I remember earlier in my first 2000, 2001, I used to do these business trips and, go to Bombay, Delhi, Bangalore, and meet, all the lawyer friends, all my lawyers over there in different sectors, and tell them, that, I'm in Calcutta, send me work, kind of a thing, introduce myself. And after a few years, I stopped it because I just couldn't handle the amount of work I was having. So, work will come even if you're in a smaller place. If you're good, you can shine anywhere. But that's my philosophy. And you'll possibly have a better standard of living also. And, live king size, no problem. Maybe in a smaller place. But, you'll get work. And then you can move to the High Court slowly and then graduate to the Supreme Court, like a lot of us have done, from High Courts, practicing in High Courts, move to the Supreme Court and doing well. Thank you.
Thank you for that, Justice Saraf. I think that, Justice Saraf, you did preempt my question. My next question to you would have been that if someone wants to start litigation, should he start from Delhi or large metropolitan cities, or should he go to his district or to smaller courts, etc.? And by saying that there is still a lot of clients, and at least a lot of cities in India are still unexplored for NLU grads, it is a fruit worth picking for newer NLU grads to go to those places.
That's precisely my point. I mean, NLU grads should actually, if they have a kind of a system in place from their local area, they should start there. What's the problem? Practice over there, learn the court craft of the lower courts, trial court, and then, slowly make your contacts and move up if you want. Take matters from your lower courts to the High Court, brief seniors in the High Court, practice and move ahead. I mean, of course, it is very individualistic. Somebody could start at the Supreme Court and do very well. Somebody could start at the High Court level and do well. It's a choice you make. As long as, you do it properly, that's what matters. My seniors used to tell me that it doesn't matter what you do. If you're a grass cutter, you be the best grass cutter. That's all. Don't be bothered about the kind of work or where you're doing the work. You must do it to the best of your knowledge and perfection. Hard work, there is no substitute. So you will have to do hard work wherever you are. But there is no harm in starting in the smaller places. In fact, that's possibly a gold mine now. Thank you.
Justice Saraf, I think that I've never seen you argue, but I think you would have been a brilliant advocate, because you've again answered the next question of mine, which was that if someone wants to start litigation, should we start from a trial court or from the Supreme Court or from the High Court? And I think your question aptly answers that. So I'm going to directly move on to my next set of questions. Is that, as Justice Govindraj and you, Mr. Saraf, very aptly, the NLS tag, a lot of people do consider it to be elite, but it would be unfair to say that NLS has been a failed experience. And also that this elitism is something which at least students have, but once you graduate, a lot of people, they know that you must work nevertheless, and they lose any conception of elitism, which, if they have any. Justice Govindraj and Justice Saraf, then I would ask you one last question. Is that, however, even considering that NLU grads decide to join the bar and they think that, okay, I have a city, I have a small tier 2 city which I can join, it has a decent high court. But nevertheless, he would still have two questions. I know you've touched upon it before, but first is of pay. He feels that I'm just not paid enough. Possibly my parents aren't rich enough to support me financially. And I have an easy avenue to go down a law firm route and at least make some money in the initial few years. How do you think this concern can be dealt with? And secondly, is there any other advice, parting advice, which both of you would like to give to young advocates to motivate them to join the bar?
Firstly, I like to give the advice first to the young members who are listening over here. One with regard to court craft, which is it is extremely important when you people graduate and become litigators, to marshal the facts very well. You know, we all think that the law is very important. We need to understand this law, that law, but it's extremely important to marshal your thoughts, prepare your list of dates. You know, that's possibly the most important thing for any litigator, you know, to have an excellent list of dates in front of him, so that the moment a judge asks you a question, you can answer it, take him to that particular page, you know, and that's how the judge knows that, yes, this person is prepared and he'll answer my question. Second advice is that when the judge is with you, never argue with him, in the sense that when you've got the pulse of the judge and the judge is dictating an order in your favor, there's a tendency of lawyers to, you know, try and put an extra point through. I've seen that work sometimes drastically against the person, and the judge may just decide to pass a completely different order. So that is something which one should be very careful to read the pulse of the judge and, you know, work accordingly. And otherwise, advice to the law school, you know, I really think you all need to enjoy yourself also while you study, and don't take, you know, in fact, there's been a worrisome trend I've seen in some of the law school of students committing suicide. I wanted to touch on this point. You know, it doesn't really matter if you've done badly in a particular year, or you know, because I'll tell you from my own experience, I did 1 year of BCom before joining law school. That really hasn't made any difference to my life. You know, I'm very happy. It makes no difference whether you know, if suppose in law school, you've, instead of taking 5 years, it took you 6 years. You know, that is not a reason to get depressed, etc. In fact, from some of my friends' experience who gave repeats and recourses, I can tell you their knowledge of that subject is far, far superior than us who only took one exam. You know, so if you take a recourse, don't worry, it's good. You learn better and possibly perform much better if you go and take up that particular subject itself in the profession. So I really advise is not to take life so seriously. It's very precious. So enjoy it, and you know, things will happen, will fall into place in time. And failure is nothing but a stepping stone to success. You know, so that's very important. We must learn to fail also. All the time we are learning to succeed. But I think what is more important is to be able to learn to fail and then rise again. That's very important. I'll let Justice Govindraj now continue.
Agree with Justice Saraf completely. Don't worry, the legal field is so vast. Many a time you take up something which you think you want to do, but then later realize that this is not something I want to do. I want to do something more or something else. Don't worry, you have to kiss a lot of frogs before you get the proverbial prince. It takes some time for you to find your own water, find your own level and say, okay, this is what I want to do. As regards the practice aspect of it, marshalling of the facts, absolutely important. The law does not change, the facts change. The facts change with each case. The decisions of the courts are fact specific. So if your facts doesn't fit the law, then you don't have a case. You might have the facts, but you haven't gathered the facts from your client. Spend some time, have empathy, listen to the client. The client does not know what is important, what is not important. You have to, it's virtually a cross-examination many a time with the clients to get the fact, because they would say, no, sir, I thought it was irrelevant. But he's nobody to say what is relevant and what is irrelevant. He does not know. It is for the lawyer to get those facts. The lawyer cannot be heard to say later that my client did not tell me this. If he had told me, I would have had, because at the end of the day, if you get an adverse judgment, the client would come back and say, sir, actually it was so. Then the lawyer turns up, why didn't you tell me earlier? Nobody asked me. So spend some time with the client, have the empathy with the client, get the details, have a good demeanor, friendliness with the client when they will have a relationship with you to give you the facts. You are a third party, finally. You're not the childhood friend or a family member. It will take some time for them to give you the facts. Spend some time with them. Marshal the facts. Make a super list of dates. That is the crucial part, as Justice Saraf said. You need a cross-reference list of dates. You should be clear. You should have the dates at your fingertips. Then identify the issues. There are issues of fact, issues of law, mixed questions of issue and facts and law. Identify it. Most of the matters have the mixed questions of fact and law. That is where the facts in law become very important. You need to marshal. Then when you present the matter before the court, present the fact as a proposition of law. When you present it in tune, in accordance with law, anybody will take it. Otherwise, if you only give a story saying that there was a king and this is what happened, that is there for your pleadings. The written advocacy, there is a oral advocacy. Be clear on it. Doing research, Manupatra, SEC has become very good, but also a bane, because you put in a keyword and you get a citation and you are happy that you hit the jackpot. Pick up the commentary, read that particular provision. Most of the times it is just around 5 pages, 10 pages, 15 pages for that particular provision. Just spend some time. So even if a question is asked by the judge a little this way or that way, because the judge probably knows or probably does not know, whichever way that a question comes, then you should not be flummoxed. You should be able to handle it well and to be able to answer it. So read up the concepts, be conceptually clear. The decisions here and there will keep happening. Conceptually be clear. Then, and most important of all, your other side lawyer is not your enemy. Your other side lawyer is your friend at the bar. You will go have coffee with him or go have a drink with him or go have dinner with him. He is there at the bar only for that matter. You are on this side, he is on the other side, he or she is on the other side. Please have courtesy and respect to the other side. As my senior told me, do unto others what you want others to do unto you. Just follow that. You are good with the other people, they will be good with you. Don't worry about it.
If I may add to that, Justice Govindraj, we had this habit of shouting at each other in court during matters, and then the other side, and we would go out and have a smoke and chai together. That was that is the practice in Calcutta, I presume. I'm sure it is the practice in other high courts also. One more thing I wanted to touch upon is with regard to ethics. I have always believed and practiced as a litigator, and I always felt that I was first the officer of the court and thereafter the lawyer to my client. And if that principle, this principle is clear to us, that we need to be true to the court first, then the court also appreciates that. And in practice, what we used to do, that if we had a weak issue, we would first lay that before the judge and tell him that this is a bad issue for me, I concede this, but kindly focus on these two other issues. So I think being truthful to the court is very, very important, and lawyers need to do this, because very quickly you might be able to fool a judge once, twice, but not the third time. So if your impression goes out to a particular judge that this guy pulls a smart one, that's the end of your career. So we need to be truthful and act as officers of the court first, before just fighting for our clients, tooth and nail. I mean, clients will come and clients will go, but your place in the court is going to remain. Thank you.
Just to add to that, what is ethics? Ethics is that small little inner voice which is telling you right from wrong. You don't need to read up ethics. You don't need to do a course on ethics. You yourself know what you're doing is right or what you're doing is wrong. And to further add on to what just Saraf said, when a client comes to you with a matter, if you are able to advise him or her in a proper manner, it may not even result in litigation. They are able to understand that this is not a matter to fight about, or this is a matter which could be resolved outside court. You could pick up the call and speak to the other side lawyer and bring about a settlement. Believe me, a client will be very happy. Don't flog the matter to say that I'm going to file it and take it up to the court. Let us see, I'll make my money. Once the client gets to know that you only flogged it, you will neither the client comes, nor have you succeeded in the matter. To facilitate a resolution of the dispute of your client, so that the client goes back from your office in a happy manner. Then, of course, as Justice Saraf said, don't flog the wrong principle or wrong argument before it won't lead you anywhere. Everybody is watching, the world is flat. Everybody knows what you did last summer.
Again,
So,
just before, one more thing I like to say is that since all these the students are going to be joining the bar, etc., honesty is very, very important, and intellectual dishonesty is the worst thing to practice. So we need to be very clear in our mind that if you're going to be a litigator, you're going to be true to your work and you're going to be true to the court. And it is you guys that we are expecting who will change the system. Like Anirudh spoke of pendency of cases. Now you see, if it is you guys who come in who will not drag matters, we are expecting that you all will try to finish off matters quickly. The traditional old way was, let a matter be there, let it continue. You must have a lot of briefs in your office. That needs to be changed. We need to finish off matters, move to the next. That's how we are intellectually stimulated. And there is an excitement that is there in the profession. Let's not hold on to matters and take adjournments in those matters. Thank you.
Thank you, sir, and thank you for this very elaborate discourse on how we should treat our colleagues and how we should not be unfair to the court. Because at the end of the day, we as lawyers are first officers to the court, and our duty is first to assist the court and not our client. Nevertheless, I would now just want to ask you a question which is strictly relevant, considering the fact that most of our audience comprises of students from national law schools. And while I do agree that these are things that can never be taught at law school, ethics cannot be taught at law school, what is right from wrong cannot be sieved at a law school. The fact of the matter is that there is an increasing debate that the standard of the national law universities is gradually decreasing. And a lot of these reasons are attributed to the lack of their independence, given the fact that they are established by state enactments, or the fact that there are lack of funds. Now, do you think in this light first that the standard of law schools has actually depleted? And if so, do you think nationalizing these law schools will be a possible solution?
Justice Govindraj will answer that.
Now you know why he's a good advocate. Your father must have told you during our time it was like this. Our time was so good, now it is so bad.
Yes, sir.
It's a common refrain. Common lament that at my time it was good, now it has become bad. If that was the way that things had to happen, we should have gone back to the Stone Age. Why are we going into AI and blockchain, etc. today? Does that reflect in the offers being made during the course of on-campus recruitment? The offers which are being made to the students of the law schools are only increasing. Everybody is just picked up on day 1, day 2, and day 3 don't exist. If what you say is true, then that should not have happened. Of course, what has happened is that there was one National Law School of India University. NLSIU caught up with it. Then West Bengal caught up with it. Various other law schools have started catching up with it. Now there are, apart from law schools, which has that aura of National Law School, there should not be any aura about it. Because we are speaking so much about National Law School, since this is supposed to be about law school, we are speaking too much about law school actually. There are so many other colleges which are much better, or which will give, as I earlier said, will give a run for the money for the law schools. So the lament of always saying that my time was good, this time is bad, will continue even after another 100 years. That was there during Mahabharata time, that was there during Ramayana time. Chanukya Niti was written because Maurya Empire did not do it. It continues. It is never going to end. It is one of the things that each law school or each college would have to look at is the academic profile and the professors as such. But if not for anything, COVID has taught us that it doesn't need to be a physical lecture. There could be a lecture which could be given from Delhi and a student in Kanyakumari could be participating in it. We should probably make use of it now. Apart therefrom, I've been following quite a few of webinars, which are, since we have time now, we have been following up a lot of webinars, which are very interesting, which have been rendered by former judges of the Supreme Court, sitting judges of the Supreme Court, former judges of the High Court, sitting judges of the High Court, senior counsels on various topics. Somebody could probably curate them topic-wise, language-wise. Let it be in local language, let it be in Hindi, let it be in Kannada, let it be in Bengali, let it be in whatever language. If you could curate it, it could be a database for not only law school, but for all colleges.
Correct.
To get to know the nuances of law of mortgage. Okay, there's a 2-hour lecture by so-and-so. Evidence, perjury, you name it, everything is available. So that could go a long way for making the education available online. Apart from that, we could also probably have an advocates academy in each state for continuing legal education. Law keeps on changing.
Thank you for that answer, Justice Govindraj and Justice Saraf. Justice Govindraj, as you mentioned, in fact, a couple of students have collated a list of all these webinars, and I'll be glad to share it with you and with anyone who messages me, and I'll probably even ask the Can Foundation to circulate it if possible. And thank you, and I'll just wrap it up with a brief summary of what we did. I think we started off with the professional journeys of Justice Saraf and Justice Govindraj, where we traced how both took slightly different paths and how going to a law firm or setting up a law firm of your own or joining a law firm is a viable alternative, as well as the fact that being a second generation lawyer is not a necessity. If you work hard, you can perform and succeed everywhere. We moved on to some court crafts and we dealt with some important issues. For example, we dealt with how can pendency be cut, whether we have an issue of low judge ratio. We dealt with our virtual court experience and talked about how we can perhaps adopt transcription as a possibility. And we talked about media coverage, etc. Finally, we have received some very good golden words of advice from Justices Govindraj and Saraf for new advocates. I think many of the snippets which you gave over here are something which I have at least written down on a piece of paper. And I'm sure that many students would have listened to you and will keep listening to you, because I hope this is on YouTube and many more people have been listening to it. And I think we have received, and I hope at least that we have been able to motivate a lot of young advocates to join the bar, go to their own cities, explore uncharted territories, and raise the standard of the Indian bar as had been originally envisaged by Professor Dr. Madhav Menon. And with that, I would like to hand over to Mr. Aditya Khandekar, the Joint Secretary of the Can Foundation.
Good evening, everyone. It has indeed been an exceptionally stimulating and inspirational session. No words of appreciation can express our deep sense of indebtedness to each of our speakers. On behalf of the Can Foundation and all, we extend a heartfelt gratitude to our esteemed panel. I am sure that in the years to come, when we remember this session, the first thought that would come to mind is that the eminent speakers were extremely warm and unassuming, and that their experience as a law student or in their early years as a lawyer have found common ground with most of our listeners, which has made the session tremendously interesting and memorable. I'm sure that we would all agree that the session has achieved its purpose of being a truly candid session. It has definitely busted some common misconceptions and myths. For example, Honorable Justice Govindraj said that it is not the number of years being spent as a junior to a particular senior that clears the path to success, but rather any route which gets a lawyer to appear in court, which can set the trajectory for a successful career. The message to our young listeners has been clear that everybody has to struggle to make a career as an advocate, whether it's a first generation one or a second generation advocate. There is no substitute for hard work. Lawyers need to be truthful. And if you're good, you can shine anywhere. Anirudh in his introduction had said that our illustrious speakers have a youthful zest. This has been amply highlighted in this session, especially during the discussion regarding live streaming of cases and how it would take away the banter from litigation. And subsequently, when our speakers modestly indicated that our student listeners need to chill out and failure is a stepping stone to success. I would like to express our gratitude to RG and UL for collaborating on this session, and in particular, Dr. Naresh Kumar Watts for the welcome address. Lastly, I would also like to thank Anirudh and Ganesh for magnificently moderating this session. Thank you everyone for attending this on behalf of Can Foundation.